Hello again, everybody. This is Craig Evans of Autism Hangout, and thank you for tuning into this Autism Hangout Special Report. One of the things that all of us are always trying to do is to find the best ways to get the most for our special kids, and that specifically applies to education. So with me today is an attorney. I'd like to have us all welcome back, please, David Tollner, and David does specialize in special education legal services for parents that are struggling to receive the appropriate education for their child with disabilities. He's been a public litigator in San Jose for 13 years, and he's been involved with many different, numerous organizations as it relates to autism. So Autism Hangout, please welcome back David Tollner. David, good to have you here.
Yeah, thank you, Craig. Good to be here.
Well, let's hope Skype cooperates for us today. And today you're going to talk about getting an independent assessment for your child at public expense. Now, why is that such an important thing?
Well, two reasons. One is you need an advocate, and you need an advocate with a specialty in your child's diagnosis. As much as you think you know everything there is to know about your child and his diagnosis, you're not going to be considered a specialist. So you need somebody who will step up to the plate for you and talk about what your child needs. And that is not your attorney or your legal advocate. That has to be a specialist in the disability area of your child. And two, if you can get the district to pay for it, why not? Because they tend to run somewhere in the $3,000 to $7,000 range, and by law, the districts have to pay for it under certain circumstances, and that's what we're going to talk about. Okay, so the school districts are required to pay for it, is that correct? Yes, under certain circumstances. So let's get right into what those circumstances are.
Good.
First rule is the district has to assess first. So it's like a second opinion that you would get of a medical diagnosis for yourself. The caveat here is we must have the district give the first diagnosis, or in this case, complete the first assessment. And then you take that assessment, and if you don't like it, and or your child at some point down the road, because the services that are provided by the district are attendant to the assessment they did, and you're not seeing the progress that you want, then you can request an IEE. And let me show you how that's done. And that IEE stands for Independent Educational Evaluation. And the law says that you can request one in writing of your school district after they have done an assessment that you want a second opinion on. Okay? So first you get an assessment, then you request an IEE in writing, and you ask for it in writing for them to do it at public expense. All right? If they ask you why you want to have that one assessment reviewed, you do not have to tell them. The law suggests, or actually explicitly says, that's not a requirement. You simply have to let them know you want it. Now, what the district will do, generally speaking, is deny your request. They do it all the time. And they do that for a number of reasons. You know, one, they don't want to spend money. Two, it might be an unreasonable request. In other words, the assessment that they did might very well be a proper and acceptable assessment of your child, and they think it's an appropriate assessment. They don't want to pay for another one. But very often they don't want to pay because it's an expense they don't want to undertake. And so you have to make them do it. And you do that by first requesting it, and then they have a certain amount of time to respond. It's different in every state. They have a reasonable amount of time. And they have only two choices. What they can do is agree to conduct or to allow you to go out and find an IEE, a specialist to conduct another assessment, or they have to deny. And they have to deny with an explanation. And then if they do deny, they're supposed to take you to due process. They're supposed to file on that very issue.
Okay.
What happens today is that districts deny without filing very often. Matter of fact, I would say it's commonplace. Far more common than them denying and then taking it to due process, because the expense of due process is more than the assessment that they're otherwise rejecting. So they will just sort of ignore that area of the law, which we will use to our advantage in a few minutes as I talk about what happens then.
Okay.
So now you've made your written request. You've asked for it to be a public expense. The district has come back and denied your request. You still go out and you get your assessment. You need that. In almost every single case that comes to me, they either have already had an IEE, or the first thing I do is make sure that they get an IE, because we need someone on our side. Okay, and it isn't just me. I need to be able to refer to somebody who has a background and the credentials in your child's disorder. So I always have an IE in place before I go into the next IEP. So you've done that now. You've gone out. You probably had to pay out of your pocket. You've got a report in front of you created by a specialist that has recommendations about what your child needs along the lines of what you agree your child needs, obviously. And typically, of course, the point in doing this is that your recommendations are different than the district's recommendation. You take that document, and this is an important point, you take that specialist and you go to your next IEP. So that means the specialist you're looking for has to be an advocate for you. It's not enough just to write a report and send you off with it. They have to be willing to come and attend an IEP with you and discuss their report and why their recommendations are solid and appropriate for your child. Without that, it's not as meaningful. Okay. So now you've got your IEP. They've come and they've given their information. Okay, they've talked about their assessment of your child and they've made recommendations. What that does is it sets on the record a different viewpoint of what your child needs than what the district is offering. And that's very important for moving forward and actually getting that. Even if the district doesn't pay for your IEE, by law, they are required to consider the information therein, which is why you have your specialist, your doctor, your PhD, whoever it is, your SLP, why you have them there at the IEP with you. All right? Let's say all of that's done. Let's say the district, as a result of that, says, all right, we're going to give the services you want, okay, which happens. I'm not seeing that as much because if I'm involved generally that there is that debate between the district and the parent. So let's say that happens. You then at the IEP, you request again reimbursement for your IEE. If they refuse, but you like the services, you can always sign the IEP. You can consent to it with the exception of reimbursement for IEE, which is still on the table. Okay? So make sure you do that. If you like the services, go ahead and consent so they can start those services, but make an exception of the IEE reimbursement.
You actually write that next to your signature?
And write that right next to your signature.
Okay.
Okay? Do anything else. Just make sure right next to your signature with the exception of IEE reimbursement, which has been refused.
Okay.
Okay? That opens the door for you to file for due process on that singular issue. Now remember, when you file for due process on a singular issue, if you do it yourself, the filing isn't that expensive. As a matter of fact, it's free. I mean, so it's your time in putting the paperwork together. Because it's a singular issue, it's not very complicated. And then by law, there's a mediation. And generally speaking, a district is going to agree to pay a $3,000, $4,000, $5,000, $6,000 IEE rather than pay an attorney to either to come to mediation and negotiate that fee or take it to due process, particularly if they did not follow the law in the first place by taking the case to due process themselves. If they know there's a violation there, that's not going to sit well with the hearing officer. And 95% of the time, Craig, that stuff settles, all of that, settles that mediation before you have to go to hearing.
Excellent. That's just good news all the way around. I mean, we all realize the school districts are taxed and they're trying to do the best that they can, and we realize that we have to be advocates for our kids, but in negotiating the way you just put this strategy on the table, the most important thing is our kids win. They get the best education possible. David, how can people get more information or get in touch with you?
Well, to get in touch with me, probably the easiest way is my email, like it is for all of us. David Tollner at Gmail. Very simple, DAVID TOLLNER at Gmail. I'm happy to respond to emails that come in.
Excellent. David, thank you so much for taking the time today and sharing your wisdom and your expertise with the audience here at Autism Hangout. It's very much appreciated.
My pleasure, Craig.
And thank you, Autism Hangout, for tuning in. I'll be back again soon with another special report.